Hi everyone, my name is Abdullah, and in this presentation I will critically analyze the role of alternative dispute resolution in access to justice with a reference to the UK jurisdiction. The presentation consists of three parts. First, introduction, and the body part is access to justice in the UK, ADR mechanisms as a key to justice, advantages and disadvantages of ADR, mediation as a tool for access to justice in the UK, and last part is conclusion. The traditional method of access to justice is the use of state judicial mechanisms that in a sense implies applying to a court for protection of rights. It is commonly accepted that the judicial system is the most effective way to resolve disputes. In contrast, other methods of resolving disputes such as arbitration or mediation are commonly referred as alternative methods. Therefore, to answer the question of the extent to which ADR provides access to justice, it is prudent to consider it in comparison with the judicial system by comparing advantages and disadvantages of each. Access to justice in the United Kingdom. The term access to justice can be interpreted as access to the dispute resolution mechanisms that are provided by the state. The initial goal of a dispute resolution system is to ensure justice in society. Over the years, many countries, including the UK, have introduced ADR methods in their laws, including courts. In England and Wales, ADRs are widely used in civil matters. The volumes of cases that cover ADRs are vast, ranging from major commercial disputes to family relationships. ADR mechanisms as a key to justice. For the development of ADR in 2013, the European Commission adopted Directive 2013-11. The directive is aimed at developing ADRs in member countries by creating certification and monitoring rules, as well as at facilitating access to ADRs for consumers of member states. Furthermore, for the development of ADR, the United Commission in 2013 adopted Regulation 524/2013 that specifies the outline dispute resolution for consumer disputes (ODR). The regulation governs the use of ODR, which applies to all transactions made over the Internet. To support the ODR, the Commission created the European ODR platform, which is a multilingual interactive website through which consumers can submit their disputes for the online consideration. In 2018, the UK-based ICF Consulting Service Limited conducted a research to assess the effectiveness of both ADRs and courts in resolving consumer disputes. The report showed that 62% of respondents who used ADRs and 53% of people who used courts found them affordable and straightforward. The report also showed a perception of justice that was associated with the outcome of the cases. For example, in cases where consumers won the case, 83% considered ADR fair. However, consumers' perception of justice through ADR fell to 19% when no decision was made in their favor. Advantages and disadvantages of ADR. When considering ADR as a tool for accessing justice, it is often compared to the traditional judicial system. ADR has both advantages and disadvantages compared to the judicial mechanism. One of the essential benefits of ADR is its low costs. In other words, settling a dispute could be cheaper for disputing parties than going to court. One of the most important advantages of ADR is the possibility to choose a mediator. In other words, the party can choose the person who should consider their dispute, depending on the category of the dispute. For example, if the debate is about cryptocurrencies or at fintech, it is quite evident that the parties need to choose a mediator who is well versed in those issues. Another significant advantage is the relatively short terms of consideration and confidentiality. This factor is essential for legal entities in particular, as many companies do not want to make the dispute public, so as to avoid a negative impact on their reputation, and ADR guarantees confidentiality in this regard. Despite the above advantages, ADR has some serious disadvantages compared to the judicial system, which include the fact that the parties may be forced to compromise, that is, to make some concessions even if they have the legal right to claim more benefits. Another shortcoming of ADRs is the lack of power that judges have. For example, if a dispute is considered in court, the judge has the right to impose restrictive measures on the assets of the company, in the use of any property, which in turn induce the guilty party to put every effort to resolve the dispute as soon as possible, whereas in ADRs, mediators are not authorized to apply such measures, which in turn affect the effectiveness of this method. The ADR requires the parties to be prepared to negotiation and solve the problem. However, in cases where one of the parties is against of negotiation, it is preferable to turn to the court. Mediation as a tool for access to justice in the UK. The glossary to the civil procedure rules defines alternative dispute resolution as collective description of methods of resolving disputes otherwise than through the normal trial process. Measures aimed at developing mediation in the UK include the 1996 Access to Justice Report, which is a catalyst for the development of mediation in England and Wales, as well as the Directive 2008 EU on specific aspects of mediation in civil and commercial matters, which regulates the use of mediation in the EU. Mediation is one of the easiest and most effective ways to resolve a dispute. The main purpose of mediation is to assist the conflicting parties so that they change their confrontational position and reach a mutual agreement. One of the reasons for choosing mediation is the desire of the parties to maintain friendship after the conflict. In conclusion, considering the advantages of ADRs as mentioned above, it is fair to say that the term appropriate is more appropriate than alternative to describe various non-judicial methods for resolving a dispute. The UK widely uses variety types of ADRs, but mediation remains one of the most common and effective ways to resolve a dispute. ADR has both advantages and disadvantages. However, in terms of its contribution to providing access to justice, it certainly plays a vital role, as in addition to the judicial system, it contributes to the variety of dispute resolution methods. And that's all. Thank you for your attention.